I don't understand how your argument about preemption here squares with the theory of spending clause, of Congress's spending clause power. The theory is Congress can tell a state or any other entity or person, look, here's some money or other thing of value, and if you want to accept it, fine, then you have to accept certain conditions. But how does the Congress's ability to do that authorize it to impose duties on another party that has not agreed to accept this money?
There are no duties being imposed on Idaho here. It's not required to provide emergency stabilizing treatment itself. The duties are
well, all right, not duties. How can you impose restrictions on what Idaho can criminalize simply because hospitals in Idaho have chosen to participate in Medicare? I don't understand how this squares with the whole theory of the spending clause.
Well, I think that it squares with this court's long line of precedents cited at page 46.
Well, I've looked at those cases. I haven't found any square discussion of this particular issue, but I'm interested in the theory. Can you just explain how it works in theory?
Sure. So spending clause legislation is federal law. It's passed by both houses of Congress. It's signed by the president. It qualifies as law within the meaning of the Supremacy Clause.
Absolutely. Absolutely.
And so I think the Supremacy Clause dictates the relevant principle here, that in a situation where...
I'll let you finish, yes. Go ahead.
In a situation where Congress has enacted law, it has full force and effect under the Supremacy Clause, and what a state can't do is interpose its own law as a direct obstacle to being able to fulfill the federal funding conditions. And this theory, Justice Alito, would mean no conditions under Medicare are enforceable.
No, they're absolutely enforceable against the hospital that chooses to participate.
Well, I guess the argument then would be that if a hospital is instead bound by the state law and the state law gets to control, it would mean that hospitals couldn't participate in Medicare at all. And that's not the argument that the state's making here. What it wants is for its hospitals to be able to accept Medicare funding, but not have to face the restrictions that are attached to those funds as an essential part of the bargain. And there is no precedent to support that outcome.
Well, I just don't think, I don't understand how the theory works. But let me move on to something else. I'm going to try to restate your general theory, and I want you to tell me if this is right. I think your argument is if a woman goes to an emergency room and she has a condition that requires an abortion in order to eliminate quote-unquote serious jeopardy to her quote-unquote health, the hospital must perform the abortion or transfer the woman to another hospital where that can be done. Is that a fair statement of your argument?
So it includes not just serious jeopardy to her health, but obviously also serious dysfunction of her bodily organs or serious impairment of a bodily function. And the other caveat I would make is that it would require pregnancy termination only in a circumstance where that's the only possible way to stabilize her and prevent that cascade of health consequences.
Does this apply at any point in pregnancy?
So the pregnancy complications that we have focused on generally occur in early pregnancy, often before the point of viability. There can be complications that happen after viability, but there the standard of care is to deliver the baby if you need the pregnancy to end because it's causing these severe health consequences for the mom.
Well, what if it occurs at a point where delivering the baby is not an option? You're out of the third trimester, but it's really not an option to deliver the baby.
You said that you're in the third trimester?
No, I'm sorry, out of the first trimester.
So if you're contemplating a situation where delivery is not an option, then I think in that circumstance, if the only way to prevent grave risk to the woman's health or life is for the pregnancy to end and termination is the only option, then yes, that's the required care that EMTALA has through its stabilization mandate. But critically, in many of these cases, the very same pregnancy complication means the fetus can't survive regardless.
I understand that.
There's not going to be any way to sustain that pregnancy.
Let me ask you squarely the question that was discussed during Mr. Turner's argument. Does the term health in EMTALA mean just physical health, or does it also include mental health?
There can be grave mental health emergencies, but EMTALA could never require pregnancy termination as the stabilizing care.
Why?
And here's why. It's because that wouldn't do anything to address the underlying brain chemistry issue that's causing the mental health emergency in the first place. This is not about mental health generally. This is about treatment by ER doctors in an emergency room. And when a woman comes in with some grave mental health emergency, if she happens to be pregnant, it would be incredibly unethical to terminate her pregnancy. She might not be in a position to give any informed consent. Instead, the way you treat mental health emergency is to address what's happening in the brain. If you're having a psychotic episode, you administer antipsychotics.
Well, I really want a simple, clear-cut answer to this question so that going forward, everybody will know what the federal government's position is. Does health mean only physical health, or does it also include mental health?
With respect to what qualifies as an emergency medical condition, it can include grave mental health emergencies, but let me be very clear about our position. That could never lead to pregnancy termination because that is not the accepted standard of practice to treat any mental health emergency.
Does the term serious jeopardy in E11 little I mean an immediate serious risk, or may a risk of serious consequences at some future point suffice?
The standards is defined in terms of whether you need immediate medical treatment. And so the relevant question is, in the absence of immediate medical treatment, are you going to have this serious jeopardy to your health, dysfunction of your organs? Will your bodily system start shutting down? So it is pegged to the urgency of acute care in an emergency room.
So it has to be immediate.
The relevant standard under the statute is phrased in terms of whether these consequences will occur without immediate treatment. Yes, so it's focused on the interaction between having some kind of urgent health crisis that takes you to an emergency room in the first place, and then how proximate these consequences are likely to be.
Well, there are two different things there. Whether the woman is in immediate jeopardy, or whether the woman needs immediate care in order to eliminate jeopardy at a later point. So I understand your answer to be that the woman need not be in immediate jeopardy, but if she doesn't get care right away, jeopardy at some future point may suffice.
So the statutory standard itself is focused on immediate health risks. It's looking at the possibility that if the woman doesn't get treatment then and there, what will happen, what will reasonably be expected to occur is that her organs could start shutting down, or she might lose her fertility or have other serious health consequences. It is focused on this temporal link between the immediate need for treatment, which is, I think, reflective of the fact that Congress was narrowly focused on this emergency acute medical situation.
Do the terms impairment to bodily functions or serious dysfunction of any bodily organ or part refer only to permanent impairment or dysfunction? Does it also refer to temporary impairment or dysfunction?
I think it can also refer to temporary impairment, but I'm not sure that it's easy to parse the two. For example, a lot of times a pregnant woman in distress, she might start suffering liver damage or kidney malfunction, and you don't know ex ante whether that's going to be permanent or not. The instruction that Congress gave in EMTALA is you need to stabilize to guard against those very serious health risks.